Okay, I have Adanté Pointer with me. He's a civil rights attorney. He's joining us. Adanté, I'm going to give you first. I'm sitting here. It started in disbelief. Okay, and in addition to this ex parte hearing that, in my opinion, should not have occurred, in addition to the fact that it's opaque, which the rules are not supposed to be for defendants, that they don't even know it was discussed during this hearing with the individual who's on. I want to make sure we get this right. You tell me if I'm wrong, Adanté. With the witness who's on the stand who invoked his right to remain silent last week, but after having an opportunity to speak to the judge in chambers, which I've never heard of in over 30 years of practicing law, and with two prosecutors there, and without the defense even knowing, now is on the witness stand. And to add more to central casting of insanity and crazy, some lawyer pops out of the woodwork who supposedly represents him. He says to her from the stand, "You're fired." She wants to tell the judge about something that went on in the ex parte conversation. Who knows? It could be something to do with illegality. It could have something to do with the client wanted her to do something that was unethical. It could have a million things that could be relevant to this witness's testimony. And the judge is kind of now doesn't know what to do. Listen, I think, guys, tell me if I'm wrong. Adanté, you first. That those people who they hire to write bar exam questions, those people that sit there to find the twistiest way of writing things, that you look at it when you're reading, you say, I can't believe I don't know how to figure this scrambled egg out. Like, it's like that guy wrote this script, Adanté.
Yeah, and if this was a bar exam question, it's set up for people to fail, not because the complexity per se, but because the length of the objections and the rules that come into play. And a person would not have enough time to fully issue spot and then address each and every misstep or issue that has been posed and raised by what's going on in this courtroom. I think this has mistrial. I think this has appeal written all over it, front to back, and it's gift wrapped to the defendant. He'll have another day in court, based just solely upon what we see right here going on.
Yeah, now, before the break, we were listening to arguments regarding an attorney for a key witness in the Young Thug RICO trial requesting to be recused from the case. Now, this is, we'll get into it in a second. This is attorney for YSL affiliate Kenneth Lil Woody Copeland. You see his picture right there, who was arrested Friday following pleading the fifth in front of the jury. He finally returned to the stand today. Okay, guys, let's set this up for our audience, because I was kind of laughing to myself. He took the fifth on Friday. He's there today testifying because in the interim, Brian Steele, the defense attorney, finds out an ex parte conversation happens, for our viewers who are just joining us, with the judge. The witness on the stand, never heard of in my entire career in a judge's chambers. Okay. With two assistant ADAs, and allegedly a threat was made, or at least that's a defense allegation, that if he didn't testify, then he was going to spend his time in jail in contempt until the entire trial of all the co-defendants was resolved, and now he's on the witness stand. Now, we don't have the transcript of what went on in that chambers because the judge was more concerned about finding out who ratted out the judge and getting the name of the individual as opposed to the substance of why this ex parte outside the presence of the defense attorney's questioning occurred. Then, out of nowhere, it's like a cartoon thing here. Like, you're getting ready to go, and that guy's on the stand, and his civil lawyer, as best as we can figure it out, is just somebody just popped up to me, at least, I don't know about you guys, who said, "Judge, I want to be recused from the case." And so our audience understands from the witness stand, the guy's like, "You're fired," or something to that effect. And she's like, "Well, I want out." The judge then retorts, "Well, wait a second, you never filed a notice of appearance in the first place." So now we have a person who was involved in this case who had not filed an appearance with the court. Let's hope she's really an attorney. We'll presume she is. The judge did, and the court did no due diligence with respect to any of that. But then the judge invokes a rule that says once you are in the case, you have to file a motion in 20 days, and he has a right to be heard as to whether you can get out of the case or not. But here's the thing, gentlemen. He says she's fired. She's making it very clear by her gyrations because she wants to go up to the bench. She doesn't want to be said publicly. She's got something to say. There's many reasons where an attorney cannot ethically continue with representation of an individual. This guy's literally on the witness stand saying he doesn't want his lawyer. Guys, I consider that what's called the breakdown of the attorney-client communication. I don't know about you guys, but I see you shaking your heads in the affirmative. And yet this judge is forcing her to go forward with this. This is just sheer insanity. So, Adanté, I want to go back with you for a second. And like, there could be a lot that's going on here that could affect the substantive trial that's going on right now and could affect the rights of the person on the witness stand. Do you believe that the judge needs to back up and redo this, let go of the ego, undo the Brian Steele thing, try to get to the bottom of this to save this from reversal or potentially a mistrial?
I think the judge absolutely needs to do that. I've had several trials where a witness does not want to testify. They try to plead the fifth, or they're just not going to answer, and a judge is threatened to hold them in contempt of court. But that's done in open court. That's done with the defense and the prosecution present. That's not done in chambers where one party is not present. That's highly unusual for that to happen. Then to continue this where his attorney, who's his attorney, but has not made a record of being the attorney in court, wants to withdraw, and the court is going to compel her to stay there and represent him when she's saying, he fired me, I do not want to represent him. And she asked for a sidebar, which he was reluctant to give, and then he gives it and then keeps the defense attorney from being present. And once again, another ex-party communication about the same witness who doesn't want to testify, and the defense is excluded from being a part of that conversation, and there's no record. This is just unsightly for a courtroom. And once again, I think it's gift wrap present to the defense for a mistrial.
Yeah. All right, before the break, we were listening to arguments outside of the presence of the jury regarding an attorney for YSL affiliate Kenneth Lil Woody Copeland requesting to recuse herself from the case. So, Adanté, let me go back to you for a second. We were talking, off break about, how this thing can kind of go down a rabbit hole and kind of keep escalating, and the judge may be unable to get out of the wobbliness of the situation. Talk to me about your thoughts about this, because I think this is one of the most unusual courtroom developments from a legal thicket point of view. Ethics, rights of the defendant that's on trial right now, rights of a witness that's on the stand who refused to testify, but now essentially the argument by the defense is being forced to testify. What do you think?
I think the judge has certainly gone down a rabbit hole, one of which he may not be able to climb back out of, because the original sin, if you so to speak, around this issue that is now mushroomed into what we see in court today was ex parte communications in his chambers, no record made, and no one from the defense side being present with this very same witness. And so now this witness is on the stand. They're talking about an attorney who's supposed to be representing him that's not in court, that has some sort of special appearance being made by a whole different attorney who's saying she was fired and has not made an appearance and was only there for a limited purpose dealing with the civil contempt, that the judge is now trying to force to be there and represent this witness while during the course of the actual criminal trial. The maze of spider webs here where everything is getting stuck, it just may be too big to unwind at this point. And frankly, they may have to just have a reset. If it's my courtroom, I'm probably going to take a break, as the judge finally did, and I'm going to try to unwind this with protecting the ultimate decision that the jury makes. Otherwise, it's a waste of time for everybody, because this is a mystery.
Yeah. All right. So we have Ms. Haggerty coming up here from the Law and Crime Network. So I want to thank you two guys very much, but don't go anywhere, because she's going to break down more of these amazing developments. Have a great rest of your week.